like you, be strong to hold the powers of the sun.
It is the world that has been pulled over your eyes to blind you from the truth.
I show you how deep the rabbit hole goes. All I'm offering is the truth, nothing more.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case as promised. In this episode, we are going to go through all of the defense filings as it relates to the motions in limine, and I will break each and every one down for you. And I have put in some work on this one for you folks to make sure that I have backed up every single thing that I have said in this video with factual evidence to back up my assertions. In all of the motions in limine, I think one thing you're going to easily realize is there is nothing that the defense is asking for in their motions in limine that is unreasonable in any way, unlike the state's motions in limine that ask for the defense to not have a case at all. These things are not only reasonable, but they should definitely be granted by the judge. There's only one that may not be granted by the judge, and that is the exclusion of the IGG, which in my humble opinion, since the prosecution said throughout the entire case that they weren't going to use the IGG at trial, I think the judge should exclude it as well. But I believe since he ruled on the IGG being okay during that, Frank's hearing, that he probably will allow it now, which will give the prosecution an edge as far as how they got to Kohberger, because without the IGG, they wouldn't be able to explain it to a jury. So the motions in limine filed by the defense, though, they are quite interesting, and it lets us in on a lot of information about this case. Some of the things are very telling. So I'm going to go through each and every one of them with you, and we're going to unequivocally determine whether, first of all, we'll list exactly what the motion in limine is. We'll list whether or not we feel like it's a motion in limine to exclude evidence or include evidence in each one, and then I'll give you the factual information that backs up the conclusions. Are you ready? Let's go. Okay, so here is the first one, and what's nice is in the defense's motions in limine, they numbered them. See, number one. So motion in limine, RE, inflammatory evidence. Well, we can absolutely ascertain that this is to exclude inflammatory evidence. And just so you know, inflammatory evidence in a court case refers to evidence that is likely to evoke strong emotional responses from the jury, potentially causing them to make decisions based on prejudice or sympathy rather than the facts of the case, often including graphic or gruesome images, highly personal details, or statements designed to incite anger or hatred, which could outweigh its relevance to the case at hand. Essentially, evidence that is more likely to stir up emotions than provide factual information. So, absolutely, he needs to exclude inflammatory evidence if inflammatory evidence does nothing to allude to the facts of the case, but only to create prejudice or sympathy based on emotion. So I imagine if the judge was to grant the exclusion of the inflammatory evidence, that would be something that the defense would still have to watch for during trial and object as it came up. And in their objection, they could cite inflammatory evidence, and the judge would be forced to rule in their favor if it indeed was inflammatory evidence. So this is a very reasonable exclusion by the defense. I think you would agree on that. Next, motion in limine, vague and undisclosed expert testimony. We can absolutely determine this is to exclude vague and undisclosed expert testimony. And I will rely on the defense's motion to their objection to the I believe it was the ICR. Was his objection to their state's expert disclosure is what it was. But you can see right here, comes now Bryan C. Kohberger, buying through his attorneys of record, and hereby moves this honorable court for an order to compel complete expert disclosures from the state in this matter, and requests sanctions pursuant to Idaho Criminal Rule 16. The bulk of the state's expert disclosures fail to include opinions and reports. These inadequate disclosures greatly prejudice Mr. Kohberger, who is obligated to submit defense guilt phase expert disclosures by January 23rd, 2025. So you can see this was a objection that they filed a while back. And in the hearing, we all heard the judge, absolutely school the prosecution on the fact that they needed to provide additional disclosures for their experts and to over disclose if anything. Well, we can base this motion in limine on vague and undisclosed expert testimony as reason to believe that they did not add additional expert testimony to their filings and their discovery, and absolutely the judge told them to, so this should be excluded. If it's vague and undisclosed, the judge should absolutely exclude it. Next, we have the motion in limine for the use of the term murder and motions in limine using the term psychopath or sociopath. Well, we can absolutely determine these are both motions to exclude. So not an unreasonable thing. The defense does not want the prosecution using the term murder or psychopath or sociopath as they make their open and closing statements and as they question witnesses during the trial. Very fair, reasonable thing to ask for. Again, the defense's things they're asking for either have real standing on the court record or they're just common sense things to ask for, unlike the prosecution that's asking for the defense's whole case to be thrown out. Now, this one is interesting. You can see right here, this is a motion in limine, and it says R.E. Rilene Nolan, we just went over her in the last video, and reference to touch and contact DNA. We can absolutely determine this is a motion to exclude. The defense wants Rilene Nolan specifically to not be able to use the terms touch or contact DNA. Now, when you look up the possible names for this type of DNA, you'll see one is touch, one is contact, but then you'll see there is trace, transfer, and low copy number DNA. So the reason that it is specific to Rilene Nolan that they do not want her using the terms touch and contact is because, as you can see right here in the state's expert witness disclosure, for S21, the state disclosed Rilene Nolan as an expert. It is anticipated that this witness is actually a rebuttal witness who is prepared to testify regarding secondary transfer if necessary. The state contends the notice provided is sufficient pursuant to Rule 16b-7, but reserves the right to amend this disclosure upon review of defendant's guilt phase experts and pending discovery disclosure. So, the reason that they want her to absolutely exclude the terms touch and contact DNA is because if Rilene Nolan is called as an expert, she is going to be a rebuttal expert meant to rebut the defense's expert. And she's specifically rebutting the defense's expert as it relates to secondary transfer if necessary. So when you talk about touch DNA as it relates to secondary transfer, well, then the words touch and contact have no relevance in there. If they're only testifying as a rebuttal witness to secondary transfer, then the terms trace, transfer, or low copy number DNA would be more applicable to that expert's testimony. So the judge should absolutely exclude Rilene Nolan from saying touch and contact when she's describing this type of DNA based on the fact that she's a rebuttal witness testifying to secondary transfer only. So that is a great argument. Next, motion in limine, witness identification by bushy eyebrows. Well, we can absolutely determine this is to exclude the bushy eyebrows from the trial. And here is good standing for this to be excluded based on the court record. And this is out of the judge's own words in his ruling. And it says, it's talking about DM, because she's the only one that has identified, the suspect as having bushy eyebrows. But when you dive into what the judge says in the record, then you'll see why this should be excluded. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mowry later that day. So the first time she talks to Nunez, she don't mention the vacuum. The second time, when she talks to Mowry, she mentions a vacuum, as well as to Detective Gooch a few days later after that. And then it says she also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their color. Likewise, told Detective Mowry she could not remember the color of his eyebrows. So, in these 3 interviews with DM with these 3 different investigators, the first interview with Nunez, she didn't mention anything about bushy eyebrows. The second interview with Mowry, she didn't mention anything about bushy eyebrows. She just said she didn't know what color the suspect's eyebrows were. It wasn't until the third interview several days later with Gooch that she remembered that the eyebrows were bushy. Well, that certainly is not consistent in the third interview with the first and second interviews. So from a judge's ruling standpoint, he absolutely should exclude the bushy eyebrows, considering that this witness is totally unreliable. And the only thing that I've heard come out of Nancy Grace's mouth here lately that I agree with is I was watching her talk to a panel last night about this particular aspect, and she was arguing with the panel, and she was telling them, because Nancy Grace was a prosecutor, they were trying to pick and choose out of DM statements, cherry pick what they wanted and leave what they didn't. And when they were talking about the vacuum, they were trying to justify it as a kill kit and all kinds of crap. Nancy Grace said, look, the witness said it was a vacuum type object. So you either say it's a vacuum type object or you throw out her entire testimony. You can't pick one thing and then discard another. And that's the way that an attorney would look at that. So I think the judge absolutely, when looking at it from this perspective, should exclude the bushy eyebrows from being brought up in trial as an identification. Next, we have the motion in limine for the unnoticed 404B evidence. Again, we can determine this is to exclude the unnoticed 404B evidence. And the reason it says unnoticed is because you can see right here, notice of intent to use the 404B evidence. Well, it was unnoticed until they noticed it right here on the 4th day of February 2025. And the evidence is the video of the traffic stop at West Pullman Road and Farm Road in Moscow, Idaho on August 21st, 2022, involving Kohberger and Corporal Darren Duke. So they want it excluded because they did not file a notice for it until the 4th day of February 2025. And that's why it's titled Unnoticed 404B Evidence. And obviously it should be excluded because of the late notice of the filing. Next, we have the one that I think is the most important one in this thing. And this is the one that upsets me more than any. But as you look at this motion in limine, it's excluding the Amazon click activity evidence at trial. It doesn't say excluding the purchase activity from Amazon of a K-bar knife it says excluding the click activity evidence at trial. Now, what's interesting, and you can bet this is to exclude the click activity evidence, but what upsets me with this is you can go back to right when Kohberger was arrested and all of the public statements by Steve G, including in his Steve G text. He specifically says in his text, they got Kohberger buying the K-bar off Amazon. And that statement and the other statements that he made to the public that to this day have mainstream morons saying that they have Kohberger on record buying a K-bar from Amazon, they still say it to this day. And when you look at the warrant that they're trying to exclude the click activity from, this was not the initial Amazon warrants that were filed back in November of 2022. Look right here. This particular warrant was filed by Mowry on May 8th, 2023. A long time after Steve G told everybody in the world that they had Kohberger buying a K-bar off Amazon. And if they already had him buying a K-bar off Amazon through the initial warrants, then they certainly wouldn't have needed this one. And they would be asking to exclude a lot more than click activity. But they filed for the warrant on May 8th. They're looking to exclude the click activity. Why? Because when you look at this warrant, what did they get? They wanted from, let's see. Okay, give me proof of this day. This day showing probable cause, establishing grounds for issuing a search warrant, probable cause to believe there's information regarding the crimes of homicide and burglary occurring at 1122 King Road, Moscow, Idaho, on or about November 13 is one of the following Amazon accounts for March 20th, 2022 through March 30th, 2022, and November 1st, 2022 through December 6th, 2022. What did they want? They wanted all of it. You can bet this says Bryan Kohberger, but it's redacted, but it says to include all detailed customer click activity pertaining to knives and accessories, detailed payment methods for orders made on the account, all details of items in cart included, all items added to cart, items removed or deleted from cart, and items saved in cart. All suggestions made to the account, including any and all data maintained by Amazon. But what are they looking to exclude? Any of this stuff? No. They don't even have Kohberger not only not buying something, but they don't even have him putting it in his cart. All they have is the detailed customer click activity pertaining to knives and accessories. So if Kohberger's scanning through Amazon and he just clicked on a knife to look at it, they're going to try to enter that into trial as evidence. So, yeah, no, Mr. G, you got no purchasing from Amazon for Kohberger buying any K-bar knife, or else this would have never been brought up. And, yeah, Judge, you need to exclude the Amazon click activity because I've clicked on stuff on Amazon before that I didn't even mean to click on. And I would hate to, find myself on trial and them saying that, I clicked on a vacation accidentally to Belize and they're assuming that I'm trying to flee the country because I've committed a crime. I mean, that's the kind of crap that would lead to. So, yeah, exclude that one. Now, next we have motion in limine, number 10, improper expert opinion testimony, Middleman. Well, here's Mr. Middleman right here, and he's the head of Othram Labs. So you can bet they want to exclude his testimony, and they have good standing to do so. Because here is the testimony of Rilene Nolan as it relates to Othram. And it says lab bench notes by Ann Taylor. She was explaining to the court what she was asking for. And then the witness, Rilene Nolan, says, for our laboratory, we designate those as part of our case record. I'm not familiar with what Othram designates as part of their case record, Miss Taylor. So I guess that means you don't have any of those. No, only the preliminary reports. So how are they going to put Mr. Mr. Middleman from Othram on the stand as an expert when he didn't even document the work that he did. All he did was provide a preliminary report. This one should absolutely be excluded by the judge. But thanks to this motion in limine where it lists Middleman as an expert opinion, we can now add him to our state's expert list now that it's now we're starting to get it filled in a little bit better. And if you remember in the past, I've showed you the expert list we've been keeping up with. And as we get a name and what they're doing along the way, we add that name to the list. So now we can add under one of these DNA people, David Middleman, Othram Labs, DNA related. So we are filling in this expert list. We should soon have every one of these things filled in and what they're going to testify to. So I'll leave that sitting there for a minute. If you want that, absolutely, you've got it as well. Then we've got motion in limine number 11, exclude the IGG evidence. Well, that one is self-explanatory, so we're not going to go into it, and it says exclude, so we know they want it excluded. I showed you yesterday where the prosecution wants it included. Now, then we've got number 12. This is the last one I'm going to go over. This is the motion in limine for the make and model of suspect vehicle. This is the only one that the defense wants to include, and that is make and model of suspect vehicle. And why do they want to include it? Because the BOLO that went out on December 7th for this Hyundai Elantra, you can see in the press release right here under this little date is be on the lookout for a white 2011 to 2013 Hyundai Elantra with an unknown license plate. They want this entered into the record because even what they were putting out in press releases to the public about the suspect vehicle does not match Bryan Kohberger's car. And there you have it. Now, that's the best I can do without actually seeing those motions, but I believe if the defense put anything in those motions similar to what I just put in my determination of the motions, they should all be excluded by the judge. But that's my point. When you look at all of that, but then you compare it to the video that I did yesterday on what the prosecution wants excluded, I mean, the defense wants some words excluded. The prosecution wants the entire alternative suspect defense, the alibi, the statements of BF and the text messages, the 911 call. Are you kidding me? They're wanting all of the opposing evidence in the case thrown out. The defense doesn't want them to, call Kohberger names. Judge, you got eyes on you now. I believe all of us have sent letters now to all of the important people. And I've got a lot of folks in my comment section now that actually have some pull, and they have been talking as well. So all eyes on you. Please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti's out.